Number one on the course with appeal number T8/SSS/030/2023. Apple Bank India Limited, Apple Station Revenue Service.
All the parties are adoption. The questions, listen, and how.
Appearances.
In the absence of any representation for the appellant, may I announce my appearance for the respondent, Iene Ibebas.
Remove S.
Iene S. Ibebas. My humble appearance is for the respondent.
Adams, no communication. Nobody over the afternoon. Where are you? Yes. Before the scenes, we this is true. Okay. No problem. These are our judgments. This judgment is in respect of an appeal initiated before this tribunal by the appellant. Being dissatisfied with the decision of the respondent set out the notice of revised assessment dated 19th June 2023 and the notice of refusal to amend dated the 3rd of July 2023, assessing the appellant to additional liability in the sum of 35,658,694.50. The appellant filed this appeal on the 4th of August 2023. The appellant later filed an amended notice of appeal on the 4th day of January 2024. The grounds of appeal are as follows. Ground one. I think we can take the grounds of appeal as read, because we have about I think we have about 7 grounds. We take the grounds of appeal as read.
As the tribunal pleases.
The appellant is a registered company under the Companies and Allied Matters Act 2020 and is licensed to carry on the business of banking in Nigeria. The respondent, on the other hand, is an agency of the Akwa Ibom State Government empowered to administer all relevant tax laws applicable in the Akwa Ibom State. The respondent had, by letter dated 25th August 2022, notified the appellant of his intention to carry out audits, investigation exercise on appellant's payee withholding taxes, economic development and urban development levy for the 2020 to 2021 year of assessment. The appellant, upon receipt of the notice, furnished the documents requested by the respondent. The case of the appellant is that, despite the submission of the documents requested by the respondent issued a demand notice dated 18th December 2022 and arbitrarily demanded for the sum of 126,850,765 naira 7 kobo, which was subsequently revised on the 12th of May 2023 to 62,535,4.85 upon appellant's objection. The appellant, through his letter dated 19th May 2023, objected to the respondent's revised assessment and asserted that its corrected tax liabilities stood at only 599,112 naira. Based on the appellant's objection and upon further reconciliation, the respondent then issued a revised assessment of the sum of 35,658,694 naira 54. The appellant also challenged a further revised assessment by its notice of objection dated 23rd day of June 2023, disputing the inclusion of undisclosed income and levies on non-operational branches. The appellant also alleged that the respondent understated his 2021 payee on remittance to the tune of 1,828,460.06. The fulcrum of appellant's appeal is that the respondent failed to provide particulars or a breakdown of how it arrived at total income as per bank statement, which form the basis of the undisclosed income. That lack of transparency in responding decision against the appellant offends section 35 sub 1 of the Constitutional Republic of Nigeria 1999, which guarantees fair hearing. The appellant provided all the documents requested by the respondent to audit and determine the extent of appellant's compliance with its withholding tax obligation to the respondent. However, the respondent disregarded the appellant's withholding tax schedule and remittances on agent commissions, rents, and interest, which were submitted to the respondent. The respondent wrongly charged 17% interest instead of prevailing monetary policy rates of the Central Bank of Nigeria at the time. It also imposed 17% penalty on the appellant contrary to the law. The respondent in his reply filed on the 8th April 2025 acknowledging receipt of the notice of appeal joint issues with the appellant. It is the respondent's position that the refusal of appellant to make herself available for the field audits and failure to submit full documents compelled the respondent to resort to desk audits. Despite several requests from the respondent for outstanding documents, the appellants failed to comply. The respondent, having considered the appellant's objection and having provided breakdown of the assessment to the appellant, issued a notice of refusal to amend, which is the subject of this appeal. Hearing in this appeal commenced on the 4th day of June 2025, and Mr. Adekunle Dayo, tax manager at the Jewelry & Co., tax consultant to the appellant, testified for the appellant and adopted his written statement on oath as his evidence before the tribunal. A total of 12 exhibits were tendered in support of appellant's case. He was duly cross-examined by the respondent's counsel. The respondent, on the other hand, opened his defense on the 9th December 2025 by calling his sole witness, Mr. Lawrence Kudo, head Directorate of Enforcement, Recovery and Intelligence Unit for the respondent, who testified on behalf of the respondent by adopting his written statement on oath of 8th April 2025 and relied on the SBC tendered by the appellant. Both parties exchanged their final written addresses and subsequently adopted same on the 19th January 2026, and the appeal was adjourned for judgment. The appellant formulated the following three issues for determination. 1. Whether from the facts and circumstances of this case, the revised assessment notice dated 19th June 2023 and the notice of refusal to amend dated 3rd July 2023 ought not to be set aside. 2. Whether the appellant is entitled to the relief sought in this amended notice of appeal. The respondent adopted the two issues as formulated by the appellant. To the view of this tribunal, that the two issues formulated by the appellant and adopted by the respondent will sufficiently determine the issues in contention between the parties. Submission of the parties on the issues. The appellant. The appellant in arguing the issues submitted for determination of this tribunal seeks the leave of the tribunal to argue the two issues formulated together. The appellant in arguing issue 1 and 2 together subdivided the issues under subjects. A. Whether the respondent's failure to provide the particulars and computation details of the alleged undisclosed income and his refusal to furnish documents requested by the appellant did not amount to a breach of the appellant's constitutional right to fair hearing as guaranteed under section 36 of 1 of the 1999 Constitution as amended. The appellant submitted that the failure of the respondent to provide the particulars and computation details of the alleged undisclosed income and his refusal to furnish documents requested by appellants amounts to a breach of the appellant's constitutional right to fair hearing as guaranteed under section 36. The appellant therefore relies on the cases of Alhaji Chief Yekini Otapa and Chief Arugo Sumonu and others, 1987, LPEL Laro, 2822, Supreme Court. Ariori against Elemo, 1983, 1 Supreme Court of Nigerian Law Report at page 1, and Garba against University of Ibadan, 1986, 1 Nigerian Weekly Law Report, part 18, at page 550. As submitted by the respondent did not show the appellant how it arrives at the undisclosed income, even when the appellant has stated same precisely in his ground of objection in a notice of objection dated 19th May 2023, wherein the appellant disputed the respondent's revised assessment of 62,535,004 naira 85 and asserted that his collector's liability was only 599,112 naira. Counsel further submitted that despite the appellant's efforts and repeated demands, the respondent never provided any breakdown or detail of how it arrived at the assessed liability, but rather chose to ignore the record provided by the appellant and send amounts to the breach of her right to fair hearing and breach to section 58 up to of the Personal Income Tax Act, which provides thus. On receipt of the notice of objection, the relevant tax authority may require the person giving that notice to furnish such particulars and to produce such books or other documents as the relevant tax authority may deem necessary, and may summon any person who may be able to give information which is material to the determination of the objection to attend for examination by an office of the relevant tax authority on goods or otherwise. The respondent, after the revised assessment of the appellant's tax liability to 35,658,694.50, never invited the appellant to a meeting or summoned the appellant to give information which is material. The determination of the objection raised by the appellant after respondent revised the assessment to 35,658,694 naira 52. Therefore, respondent issued a notice of refusal to amend without record to the objection raised by the appellant. Counsel further submitted that the BOG assessment is arbitrary and inconsistent with applicable law because the respondent did not provide a basis for the BOG assessment. The appellant contended that the respondent arbitrary assessment of the appellant tax liability is shown in the following instances. A. The respondent failed to consider the total monthly payee tax remittance made by the appellant, which is a sum of 26,390,345 naira 63 as against the sum of 34,561,885 naira 57, thereby understating the total monthly payee tax remittance by the sum of 1,828,460 naira 64. B. The respondent inflated and bloated the total income of the appellant's tax by adding to the gross income an unfounded credit income named undisclosed income in the sum of 39,046,816 naira 44, and thereby altering the total liability of the appellant. C. The respondents inflected and plotted the withholding tax liability on rents, interest, and agent commission for 2020 to 2021 assessment period in the sum of 1,091,418 naira to go, and thereby altering the appellant's tax liability. D. The respondent reflected tax liabilities for economic development levy, business premises renewal levy, and urban development levy for the 2021 assessment year in the sum of 5,309,000, and thereby altering the tax liability of the appellant. Council further submitted that despite the fact that the appellant submitted
His network, they are joining soon. His network.
of the appellant is valid in law. The appellant submitted that during the 2020-21 assessment period, the respondent included 9 branches of the appellant in his computation of the appellant's liability on economic development levy, business renewal levy, and urban development levy. However, 4 of those branches, the Oron branch, Ikorekweni branch, Barat Road Tuyo branch, and Ikorekweni Road branch, have ceased operation within the relevant period. The appellant referred the tribunal exhibit Echo Back 2, where the appellant provided a deed of assignment and a rent agreement for the 5 branches of the appellant that were in operation in Akwa Ibom. Despite this fact, the respondents insisted that the appellant must furnish documents of the branches that were not in operation. The appellant cited the case of Kogi State Government against and others against Joel 2024, LPEL 616 Court of Appeal, and submitted that the appellant's request is tantamount to commanding the impossibility. The appellant also submitted that it is an elementary position of law that he who alleges must prove. It is the respondent who is alleging that the appellant is operating 9 branches, and are only to prove that the other 4 closed branches are in operation. Accordingly, the imposition of any levy on the appellant closed or non-existent branches is illegal, void, and unenforceable. Then on the subhead B, whether the imposition of economic development levy, business premises renewal levy, and urban development levy on the appellant is also violates the Constitution and other external tax laws. The appellant submitted that the economic development levy, business premises renewal levy, and urban development levy are also violates the Constitution. The taxes and levies approved this for collection at 1998, and referred the tribunal to Section 4 of the 1999 Constitution, which expressly donates the legislative power of both the National Assembly and the State House of Assembly. While the National Assembly has exclusive power to make law over the items in the exclusive list, and any other matter in respect to which it is empowered to make laws in accordance with provision of the Constitution, the State House of Assembly has exclusive power to make law over the residual matter and any other matter in respect of which it is empowered to make law in accordance with the provision of the Constitution. The appellant also referred the tribunal to items 8 and 19 of the Constitution, and stated that the Constitution expressly mentioned that the National Assembly can make laws over services, taxation of income, profits, and capital gain, whereas item 7 and 8 of the concurrent list reserve for the National Assembly power to make law, the imposition of taxes on capital gains, income or profits of persons, and on documents or transactions by way of stamp duty, while Constitution authorizes the National Assembly to delegate the government of the state authority, the state, the power to collect taxes or duties under the law. It has enacted for the state taxes or duties in such a manner as to ensure that such tax or duty is not levied on the same person by more than one state. Council Appellant referred the Tribunal to the case of Attorney General Cross River State and another against March 2010 JELR 47629 order of appeal, and MTN against Abia State Government and others 2019 LPELR 46652 order of appeal at pages 25 to 37 paragraph 2, where the Court of Appeal notified the Urban Development Tax Law Cross River State for being inconsistent with Constitution as well as that of Abia State. Abia State Fiscal Infrastructural and Development Fund for being authorized the Abia State House of Assembly and contrary to provisions of the Constitution. The appellant also referred the Tribunal to Part 2 of the schedule to the provision of taxes and levies, approved list for collection and harassment, and listed taxes and levies collectible by the state government. The finally submitted that the respondent has no power under any law, any of the law or act of the National Assembly for the economic development for staff, economic development levy for organization, and urban development levy as same are unknown to law and by adoption of expressio opinions exclusive or tarious. The express mention of one thing excludes the other. The state government cannot validly create or collect taxes or levies outside this still this provided by the National Assembly in 1990 Act. B. Whether the respondent was specified in law to impose interest and penalties at the rate of 17% and 21% on the appellant's alleged tax levies, contrary to provisions of the Personal Income Tax Act and other extant tax laws. The appellant submitted a portion of interest at 17% and penalty at 21% is arbitrary, excessive, and not supported by law. The appellant referred the Tribunal to Section 94 of the Personal Income Tax Act, Type 84 Cat G8, Laws of the Federation of Nigeria 2004 as amended, which provides thus: where an employer is required under a provision of this act to make deductions from emoluments or amounts on account of emoluments paid by him an employee, such employer shall account to the relevant tax authority in such manner as the relevant tax authority may prescribe for the deductions so made, and the event of failure by the employer to make the deduction or properly account thereof. The amount thereof, together with a penalty of 10% per annum of that amount, and interest and the prevailing commercial rights shall be recordable as a debt due from the employer to the relevant tax authority. The appellant submitted for that the respondent sole witness, Mr. Rollins, would have failed on that examination to show the basis of the 21% penalty or tender the tender computation sheet demonstrating how the alleged figures were derived. E. Whether the respondent's issuance of NORA with only a 7-day ultimatum instead of statutory 30 days is not unlawful and in violation of the appellant's right of appeal under the Personal Income Tax Act and the rules of this honorable tribunal. The appellant submitted that issuance of notice of refusal to amend by the respondent with 7 days ultimatum instead of statutory 30 days is unlawful, otherwise and violation of appellant's statutory and constitutional right to fair hearing and appeal. It refers the tribunal to section 58(1), the Personal Income Tax Act, that P8, Laws of the Federation of Nigeria 2004, as amended, which enjoins a taxpayer who is dissatisfied with an assessment to file an appeal for the part appeal tribunal within 30 days after the date of service of notice of refusal to amend the assessment. The respondents in position of 7 days ultimatum contradicts the mandatory period provisions of the law. Appellant rely on the case of Saru against a bill on 1994 6 the General Law Report Part 348 at page 23 and cited International Access Limited, James Francis, 2014, Nigerian Weekly Law Report Part 1408 at page 139. The appellant completed the submission by urging the tribunal to resolve the two issues for the transition in the same field. The respondent submitted that in a past appeal, the burden of proving that assessment is excessive, arbitrary, or incorrect rests on taxpayer and refer the tribunal to the case of Mobile Nigeria Limited against FBIR 1977, FBIR 1884, Supreme Court. Nigerian Bottling Company Limited against Lagos State Board of Internal 1998. For Nigeria Weekly Law Report, Part 145 at page 417. And Federal Board of Inland Revenue against ex-movers, Nigeria Limited, 2005. For Nigeria Weekly Law Report, Part 916 at page 315. The respondent submitted that he followed all statutory procedures in issuing the assessment. Therefore, the bottom line squarely on the appellant to prove with credible and admissible evidence that the assessment of 35,658,694 naira 50 is wrong, excessive, or arbitrary. On the issue of alleged breach of fair hearing by the appellant, the respondent submitted that it never breached the appellant's right to fair hearing, as the appellant was given adequate opportunity to provide documents and defend herself. The respondent submitted for that the right to fair hearing, though fundamental, is not absolute. It must be exercised within the context of statutory obligations and refer the tribunal to the Supreme Court decision. The case of Garba University of 1986, one Nigeria Weekly Law Report Part 18, at page 550, where the court held that fair hearing encompasses the right to be heard, but it does not extend to a right to frustrate the legitimate administrative proceedings or to refuse to comply with lawful requests for information. Unquote. The respondent also submitted that the evidence before the tribunal shows that the appellant was given adequate opportunity to defend itself. The respondent invited the appellant to reconciliation meeting on 3 different occasions. Each time the appellant provided additional documents. The respondent review and reduce the appellant's assessment until final revision of 35,659,694 naira 50 crore. The respondent argued further that he provided clear, detailed breakdown at each stage, explaining the basis for each assessment component to the appellant. On the issue of undisclosed income, the respondent submitted that it arrived at the undisclosed income based on the appellant's own bank statement. Section 54 sub 2B of Peter empowered it to reject any return and determine accessible income. The respondent also made a point that when she compares the staff salaries as reflected in the appellant bank statement with the payee remittances and return filed by the appellant, there were significant discrepancies. These discrepancies constituted undisclosed income that appeared in the appellant's own record that was not reflected in his tax returns. In his further submission, the respondent posited that the appellant cannot complain about assessment based on his own document. If there were errors in the bank statement, the appellant ought to have provided correct statement to clear explanation. Instead, the appellant chose to provide documents piecemeal and challenge every assessment without substantive evidence. The respondent also submitted the evidence before the tribunal establishes the fact that the appellant refused to make itself available for few audits, despite receiving the notice in Ecobank 1 for field audit schedule for 22nd September 2022. And the applicant also failed to provide outstanding documents to the respondent despite repeated demand. The respondent contended further that the applicants refusing field audits provided document piecemeal and consistently failing to provide complete documentation amounts to a calculated strategy to stall, delay, and frustrate the respondents with simultaneous audit exercise and rely on section 47 of the Federal Income Tax Act 2020. On the issue of closed branches, the respondent submitted that the appellant failed to support her claim with credible evidence, convinced the respondent and the tribunal that the 4 branches, Oron, Ikoreponi, Barras Road, and Ikoreponi Road, were indeed closed during the assessment period. Respondent submitted further on this point that during cross-examination, the respondent's witness stated that based on the intelligence and field verification, these branches were found to be operational. The appellants, having failed to produce any contrary evidence to justify her claim, it merely relied on hearsay evidence, which is not admissible in law. To refer the tribunal case of Olale Count, in the state 2001, LPELR 2561, Supreme Court, and Adeta against Nigerian Army 2016, LPELR 40235, and Judicial Service Commission against Omo 1990. Since Nigeria will play the report, part 157 at page 407. The respondent argued further that the proposition that the law does not expect the impossible, which the appellant stated as the reason for non-production of the agreement for the branches that were not in operation, cannot avail it. If the branches were truly closed, production of evidence of closure sent to Central Bank of Nigeria, the Nigeria Deposit Insurance Corporation, shareholders, and the general public shouldn't be impossible. Finally, on this point, the appellant the respondent submitted that even if those branches were closed, the respondent submitted that even if those branches were closed mid-20, they were in operation for part of assessment period and would be liable for levies for that period. On constitutionality of respondent economic development levy, business premises renewal levy, urban development levy, the respondent submitted that the appellant's argument in respect of same field travel is a constitution and tax and levies approved for collection act is misleading and lack of understanding of the law. The Akwa State House of Assembly in the exercise of its residual power under the Constitution validly enacted the economic development levy, land use fee regulations, state revenue administration for 2020, which provides the legal framework for the collection of these taxes. The respondent submitted further that the levies and the taxes and levies approved for collection Act 1998, which the appellant rely on, did not prohibit states for imposing levy under their residual power and cannot impose the rate of levies to be collected by states. The respondent argued for that the cases of Nigeria across the state against Matthew 2010 JELR 47629 and FTN against Abia State Government 2019 LPELR 46652 are not applicable. It then referred the tribunal to the Supreme Court case decision. The Attorney General of the States against Abia 1985 LPELR 3164 Supreme Court and Attorney General Lagos State against Secretary of Federation 2004 LPELR 1368 decided by the Supreme Court, where the Supreme Court affirmed the principle that states have legislative competence over residual matters, and this includes the power to impose levies for developmental and regulatory purposes. On interest and penalties, the respondent submitted at section 42 for Peter empowers you to charge 10% penalty and interest at a prevailing commercial rate, responding at a prevailing commercial rate. The respondent submitted for that The commercial interest rate between 2020 and 2021 was between 15 to over 30%. Therefore, 17% applied by the respondent is well within the range of prevailing commercial rates. The respondent contended further that the applicant has failed to produce evidence of what commercial rates were applicable during that period. On the issue of 7 days ultimatum, the respondent submitted that the applicant misunderstands the nature and effect of 7 days period mentioned in ECO Bank 7, which notified the applicant that the respondent has refused to amend the assessment as well as demanding payment of the assessed amount within 7 days. The 7 days ultimatum has nothing to do with the applicant's right to challenge the notice within 30 days periods noted by law. The respondent submits further that the cases of salary against the Gabon 1994, since Nigeria Weekly Law Report is parts 348 and page 23, are cited the International Excess Limit against Francis 2014, 8 Nigeria Weekly Law Report, parts 1408 and page 139 are distinguishable as the facts in those cases are not the same with this appeal. The respondent finally submitted that the applicant suffered no prejudice whatsoever, as his right of appeal was unaffected. In the final analysis, the respondent submitted that his assessment was not arbitrary, as alleged by the applicant. The tax assessment is considered arbitrary, really lacks a legal or evidentiary basis. The law empowers the tax authority. Empowers the tax authority to raise a base of judgment where a taxpayer returns or records are found to be unsatisfactory or incomplete. The respondent, therefore, posited a failure of the applicant to submit adequate documents compelled her to result of base of judgment. Now, consideration of the issues. In resolving the issues in dispute and disappeal, it will be appropriate to categorize the different components the tax assessment the applicant is objecting against. The components of the notice of final revised assessment dated the 3rd of July 2023 issued and served on the applicant assessing the applicant for additional liability. The sum of 35,658,694 naira 50 kobo, which is the basis of this appeal, can be found in the exhibits ECO Bank 1 and its attachment. From our perusal of the exhibits and its attachment, I deduce that the alleged tax liabilities of the appellant is categorized into 3, namely A, payee tax liability as category A, 2, withholding tax liability as category B, and 3, other taxes, which is category C. From our perusal of exhibits ECO Bank 7, it is clear that the bulk of the assessed liability covers unrepeated payee the respondents for the years 2020 to 2021, which added up to 28,357,381 naira 48 kobo. The withholding components amounted to 1,991,413 naira 2 kobo, whilst other taxes under category C amounted to 5,309,100. In analyzing the argument of the applicant as it relates to the payee component categorized at the category A, the contention of the applicant is that the respondent used a wrong methodology in arriving at this assessment, as it took into account erroneous elements of undisclosed income, which did not emanate from the payee returns filed by the applicant to the respondents. The applicant contended that no, to the extent that the assessment was unrelated to staff emolument in the statements of accounts of the applicant's employees, the assessment of the respondent was contrary to the dictates of the applicable tax laws. The applicant's witness maintained this stance under examination and furnished documentary evidence in support of his contention. The notice of objection dated 19th May 2023, which is exhibit ECO Bank 5. The emails marked as exhibit ECO Bank 10 And the email says, market says the EcoBank 11. And payment receipts, exhibits EcoBank 12A to 12C. The response of the respondent was not a clear or categorical denial that he used the wrong methodology. Rather, the respondent sought to argue that it arrived at the assessment because the applicant failed to provide sufficient documentary evidence to enable the respondent carry out a thorough or comprehensive audit, and that the respondent was compelled to use his best of judgment. Yes. But the respondent from his witness deposition and the testimony of his witness under examination admitted that documents were presented and reconciliation meetings were held between the parties. The respondent's issuance of the NORA and demand for payment within 7 days suggests that the respondent was unwilling to be receptive to further information as it expressly appeared. If the respondents were genuinely interested in additional information to address the applicant's objections, they would not have shut the door to further protest or communication. Since the bone of the appellant's contention was that the assessment on payee was erroneous because they were based on the nebulous assessment of undisclosed income, unrelated to staff emolument. The question is, why was the respondent unwilling to share the basis of that additional assessment or give room for clarification? We do not think hiding under the cover intelligence sources is a valid response backed by law. The respondent believed the appellant was uncooperative and was hiding income that law permits the respondent to have recourse to the tribunal or a court to compel the appellant to disclose such information or documents and not to rely on best of judgment. See the MTN Nigeria Communications Limited against Anambra State General Revenue Service. Appeal number TAT Southeast Zone 005 at 2016 and GTB against the State Board of Internal Revenue 2018 LPELR at page 46307. To make matters worse for the respondent, his witness on that examination admitted that he sourced the undisclosed income from the appellant's documents. If that were correct, we do not see where the appellant in his tax returns described any sum as undisclosed. The respondent's witness, who had earlier placed reliance on paragraph 21 of his witness deposition on the fact that the basis of the final assessment was that the respondent discountenanced the alleged payee remittances without evidence of the remittance would not fall to exhibits EcoBank 9 and EcoBank 12A to 12C. Relevant examples of the presentation of the respondent's witness are set out below. Appeal counsel. Please look at exhibit EcoBank 11. Confirm if that is an email from the appellant to the respondent. The witness answered, yes, I do confirm. Please read out the documents listed 1 to 4. And what date is that email? The witness responded 26th June 2023. 1. Salary of bank. 2. Payee tax computation of the bank. 3. 2022 to 2023 staff pay slip. 4. Deed of assignment and rent agreement for the branches of the bank that are in operation. Then the question came, do you have anything before this tribunal to show as a basis for your assessment of 35,658,694.50 kobo? And the witness responded, it was based on intelligence and the documents submitted by the applicant. For instance, the branches that were said to be inactive were found to be in operation and very active. Then there was a question from the council. Talking about withholding tax, do you have any evidence of the transactions for which you assess the appellant to pay the withholding tax? And the witness responded, it was based on the information supplied by the appellant to the respondent. And the council currently confirmed that your assessment was not based on BOJ. And the witness responded, it was not based on BOJ. And that was all for the witness. The respondent has also not made a similar computation to revolt the appellant's computation as being incorrect. In the case of Opo and Umex, 1998, 7 Nigeria Weekly Law Report Parts 558 at page 451 at 460. It was held that where there is oral and documentary evidence should be used as a hanger to weigh oral evidence. The respondents did not also presume the appellant's witness on a specific aspect of his testimony, where he stated that the respondent used wrong credit entries and wrong methodology or parameters in computing the appellant's payee tax liability. In the cases of authority against the state 2012 Nigerian Tribunal report part 681 at page 415 at 436, and Agbonifo against the River 1988, 1 Nigerian Tribunal report part 70 page 2325. To assert that where a party does not accept the evidence of the witness on a material point as true, it ought to confront or challenge the witness on examination, and the failure to do so will begin to be a tacit acceptance of the truth of the witness testimony. In the case of FIRS against GC Industries Limited 2017, 4 tax law report of Nigeria and page 42, the tribunal held that a tax authority must demonstrate with credible evidence how an alleged liability arose, not merely assess it. The very fact that the respondent made 2 downward reviews of the early assessment after the appellant's objections lends credence to the appellant's case that the respondent's computation of the appellant's tax liability was inaccurate ab initio. The payee tax regime enjoins an employee to only remit income deducted as source from the payroll as tax from the employee's emolument to the tax authorities. The law does not authorize an employer to touch or collect tax from income flowing to the employees from sources other than their actual emolument. Sections 81 and 82 of the Personal Income Tax Act hereinafter computer. An employee is obligated to deduct payee as source from the employee's emolument and remit the relevant tax authority. The provisions of the aforesaid law does not permit an employer to make deduction outside emoluments nor assess payee from other sources of income of an employee that is unrelated with employment or emolument. To the extent that the revised assessment of the appellant's payee liability cannot derive from actual emoluments of the appellant's employees or exceed the actual emoluments of his employees, as shown in exhibits EcoBank 9 and EcoBank 12A to 12C. The assessment is flawed and has no legal basis. See UBA PLC against FIRS 2014, 2 Tax Law Report of Nigeria 105, and FBIR against Integrated Data Services 2012, 4 Tax Law Report of Nigeria at page 84, where it was held that it is unlawful to assess payee based on accounts credits unrelated to employment. Accordingly, the excess computation derived from the nebulous heading undisclosed income without a known or verifiable source or basis related to the actual employee emoluments. The said assessment does not constitute taxable income as envisaged under the payee tax regime under Peter. The obvious implication of this finding is that errors were made by the respondents in computing tax liability using the wrong methodology, thereby leading to inaccuracies in the respondent's tax assessment served on the appellant. In the light of our above findings, we hold that the respondents demand for sum of 28,358,381 naira for take up only assessed as unremitted payee tax liability due from the appellant to the respondent is unfounded and unjustified in law. See the button against FIRS 2016, 5 Tax Law Report of Nigeria at page 120, where it was held that where tax assessments are not based on proper interpretation of the law, they are liable to be set aside or declared null and void by a tax tribunal. With respect to the assessment of withholding tax liability under category B, the appellant also contended that this sum had been paid to the respondent. The respondent did not dispute or challenge the appellant's records on the withholding tax component of assessment under cross-examination. In the case of Amadi against Muwosu, 1992, 5 Nigeria Weekly Law Report Part 241 at page 273, and Dagash against Bulama, 2004, 14 Nigeria Weekly Law Report Part 892 at page 144-242. The court held that where a party does not accept the entire testimony or some part of the testimony of an adverse party's witness as true. But first, to cross-examine the witness, the court is entitled to treat his failure of presuming as acceptance that he does not put the testimony of the witness. While the respondent's witness was being cross-examined about withholding tax, his response was that the assets based on the appellant's records and not on base of judgment, which suggests they did not fault the appellant's record of withholding tax. For the above reason, we also hold that the appellant has complied with his withholding tax payment obligations to the respondent and is not liable for the withholding tax assessment. With respect to the appellant's tax liability for other levies under category C, the appellant has not furnished credible evidence before this tribunal to substantiate payment of urban development levy. When asked under cross-examination if he was familiar with the respondent's revenue loss, his response was as follows. Have you had the privilege of reading the respondent's loss on the following? A. Economic Development Levy Law 2000. Urban Development Law Levy Law 2000. Business Premises Registration and Renewal Law 2000. The witness answered, I'm aware of the laws, but I am not fully read. Do you know the rates of the respondent's levies on economic development levy, urban development levy, and business premises registration and renewal law levy? And the witness answered, we are relying on the rates as stated by the respondent in his letter dated 19/6/2023. However, the respondent assessed the appellant to these levies using 9 branches for the year 2021 instead of 5 branches that were in operation in 2021. If the appellant's witness had not read the laws, did not know the rates, and considered that the rates as stated in the respondent letters, there is no basis to therefore false the respondent assessment of those levies. To buttress our findings, the appellant's witness will challenge the levies on the basis that they had fewer functional bank branches at the time. Under cross-examination, admitted he was unsure of the functional branches of the bank and considered that he would not be surprised if more branches were functional at the time. He also admitted that the appellant did not inform the respondent prior to the assessment of the closure of any branch of the bank. The relevant examples of representation of the appellant's witness are shown today. You did not inform the respondent prior to the year 2020-2021 audit of the closure of any appellant branches in Akwa Ibom State. And the witness responded, I'm not aware. However, the appellant informed the respondent of the closure of his 4 branches. There is letter of objection dated 23rd June 2023. Do you have an idea of the related appellant branches and location in Akwa Ibom State? He said yes. The 4 branches we were closed in 2020 were clearly stated in my witness statement on both at paragraph 22C2. Do you have an idea about the appellant's other 5 branches, which are in operation in Akwa Ibom State? The witness responded, I can't remember. Will you be surprised to know that the Oron branch is still in operation? The witness responded, I won't be surprised because it is possible the appellant has more than 1 branch in Oron. Will you also be surprised to know that the Barras Uyo branch of the appellant is still in operation from year 2020 till date? And the witness responded, I won't be surprised because it is possible the appellant has more branches on Barras Uyo. Will your answer be the same for Ikorekweni branch and Ikorekweni Road branch? Yes, if the questions are the same. You have not visited those branches to verify for yourself? Yes, I have not. But the appellant knows the number of branches in operations in 2020. The effect of the contradiction in the evidence of appellant's witness on this material issue is very fatal. In the case of Ibekundu, Igesike, 1993 7 Supreme Court of Nigeria, Part 1, at page 150, which established and restated the long-settled position of our law that the court of law cannot pick and choose one aspect of the evidence of a party and throw away the other as the circumstances of the defense assertions present rather fundamental contradictions, speculations, and doubts. The evidence of a party, in this case, the defendant respondent, must be resolved in favor of the other party. In this case, the plaintiff appellant, which is countenance the evidence of the defendant respondent and its witnesses on the purported pledge transaction. See also a Guerzo again registered process. SACM 2014, 16 Nigeria Weekly Report, part 1434, page 433, at page 475, paragraph B to C, where the court of appeal observed that where a witness gives contradictory evidence on the same issue, the court is not in a position to choose one and reject the other. The two pieces of evidence must be rejected, and such a witness is not capable of doing it. In the same vein, the law affirms that a witness who gives contradictory evidence on an issue is not entitled to credibility. As a matter of law, no witness is entitled to the honor of credibility which has two materially inconsistent evidence given on oath by him on record. Such a witness does not deserve to be described as truth. The dictum of Iglesia Majesty in MSC is against SO even and another. 2010 Nigeria Weekly Report, part 674, page 61 and 74. Should the other this tribunal to be convinced as to its assertion that the assessments for the levies were improper, it had a duty to prove its assertion with credible evidence, as this tribunal is precluded from speculating on matters or evidence not adduced before it. In the case of Shugaba against UBN PLC, 1997, for Nigeria Weekly Report, part 500, at page 481 and 490. For this reason, we hold that the sum of 5,309,000 only being the levy for urban development and other sundry levies for the year 2020-2021 is due and outstanding against the appellant and should be paid to the respondent. For the sake of completeness, we are prepared to comment on the other grounds of the appellant's appeal, challenging the legality or constitutionality of the respondent's levies, the legality of assessment of penalty and interest, and finally, the infringement of appellant's right to fair hearing. Even if it can be argued that the tax tribunal can annul a state's revenue law, no evidence has been placed before the tribunal to justify such an exercise, and besides the relevant parties such as the state government, the State House of Assembly, who ought to be given and authorized the head on such an issue, and no parties to this appeal. For that reason, we will say no on this. On the question of the legality of penalty and interest, we agree with the submissions of the respondent that penalty and interest on outstanding tax liability are mutually exclusive under Section 84 of Peter, and hold that the contention of the appellant to the contrary is not seen. But having regards to our earlier finding on the non-validity of the pay assessment, the payment of penalty and interest in this case is new and informative. We will now also see how the appellant's right of fair hearing or right to appeal has been curtailed by the respondent's administrative demand for compliance by paying the final assessed liability within 7 days. That demand is merely a precursor to the commencement of recovery proceedings if payment is not made at the expiration of 7 days. And it does not curtail the right to appeal, which the appellant has exercised in any evidence. In the light of our findings above, this appeal succeeds in parts, and will make the following orders for the evidence of that. This appeal succeeds in parts. The appellant is discharged from liability of the revised tax assessment issued by the respondent and dated the 3rd of July 2023, except for the sum of 5,399,000 only due and outstanding of urban development levy payable by the appellant to the respondent. Third, the appellant is hereby ordered to pay the sum of 5,309,000 only as urban development levy to the respondents. The parties are to bear their respective costs. And this is the judgment of the tribunal.
Mr. Chairman and members, we are grateful for the superlative display of judicial intelligence. The judgment just delivered is well researched. We are grateful, sir.
So sorry, Mr. Chairman and members. Apologies for joining in late. I'm from the appellant. I joined while the court was, or the tribunal was reading its judgment, and I must commend the tribunal's industry and detailedness in the judgment. Thank you so much.
Sorry, who was the second person left?
name is it Emmanuel?
Who was the second person left?
Mr. Chairman is Emmanuel Ikedinobi for the appellant.
Okay, now you're who?
So we're recording you
Emmanuel.
appear.
Emmanuel Ikedinobi for the appellant.
Emmanuel who?
Ikedinobi, Ikedinobi.
IKE.
Yes, Dinobi.
Are you holding anybody's brief?
None. Yes, I'm at the firm. Yes, Mr. Chairman.
Yeah, what was your comment?
I humbly apologize for joining in late. I had some network glitch, but I joined in the course of um, when the tribunal was reading the judgment, and I stayed through the end. And I commend Mr. Chairman and the honorable members of the tribunal for the well-detailed judgment. I'm most grateful.
Okay. Go to the next case.
Number 2 on top the appeal on C8 by Secretary of the Delivery of 2025. Basically, for the people have any for the losses from market.
Appearances. Appearances. Yeah.
May please the honorable tribunal and then the portfolio. Appearing with me is PP and Gary. We humbly appear to the appellant.
They will see appearing first on the list.
I was wondering.
Hmm?
On the list, you
They
were
say
saying
people Agari, then under people Agari, you have to put them.
we should.
We are leading it from under.
Okay. I didn't see now.
We are leading it from the back door.
Mr. Chairman, shall know, that was the conversation we just had. She is my senior ordinarily, even if I were to handle the.
But by rank in the office, you are senior. Are you? I don't know.
It's a bit more.
No, I saw somewhere, I saw your rank, chief,
Assistant Chief State Counsel.
assistant chief, and I saw somewhere, I saw in some of the processes.
That's an error.
So, I saw some of the processes where, Ben, then your name, then Coco the others. Well, it's not
Who is senior?
no, there's not.
She's senior, she was called 2016.
So
she will leave you.
people should correct it. Yes, we were signing documents. I need to accept it.
Yeah.
Yes.
I look already.
Which for the respondent?
With humility and great respect to the Honorable Tribunal, Nnemeka Victor Wong is my name. I appear for the ostensible respondent in protest.
That's NV.
NV Wong.
NV1.
Yes, my lord.
You are always ostensible.
Appearing for the ostensible.
Respondent.
Why are you always offensive?
Yeah.
The matter is for ruling, my lord.
Any party rep?
No party rep.
No.
Okay.
What happened?
No.
All right.
Yeah, the matter was adjourned for ruling. Yes. Have you received any application from the applicants?
My lord, are you talking to me? No.
One. This was adjourned for ruling. One.
Yes, my lord.
There is a motion. Adams. They were not served. No? Why did you serve? One.
Yes, my lord.
There is a motion filed on the 25th of March, 2026. On the 25th of March, 2026. And it shows that you were served through your email address, which is one of the approved charges for service in this tribunal. You were served on the same day. The email was sent to you at 3:38 p.m.
My lord, I have not been served any process through my email before now. The normal virtual service I got from the tribunal was only by WhatsApp.
Okay.
And I acknowledge it immediately. My email is clogged. There are a lot of messages.
I see a recipient here to Nnemeka@gmail.com. Is that your email?
Yes, it's my email, my lord.
So it was routed to your email on the 25th of March, 2026.
I would have drawn that. I chat with the tribunal regularly on WhatsApp. They would have drawn my attention to it. I am not in dispute. I've not searched my mail to see if it was served.
When did you communicate with the tribunal?
Regularly on WhatsApp. It's only when they ask me to scan a document and send through email. Perhaps most times my application for virtual hearing that I do that.
That's why I say when last did you communicate with the tribunal through WhatsApp?
On WhatsApp. My lord, that was last week. Friday or thereabout. As recent as last week, Friday or Thursday.
Friday was about 10.
Let me confirm and be exact. I chat with
I'm informing you the records we have. And this was the mail. The mail said, yes, sir, take note that the motion on notice filed on the 25th March 2026 in respect of the above subject matter has been processed and attached accordingly. Accept the assurance of the tribunal I esteem.
My Lord, I chatted with the tribunal last on Thursday by 4:46 p.m. with the admin. And I was not, my attention was not drawn to that. But I can address the court on points of law. Such a motion for whatever it is is incompetent if it is to touch on the issue that has been reserved for ruling. And I can address the court here and now on the law against it.
How
Yes,
do
my
we
Lord.
know how do we know that the motion is incompetent without the motion being heard?
My Lord, the point I'm making is that I would have answered if I saw the motion. But in the event that I did not see the motion, which I'm not blaming on the tribunal. I'm not blaming it on the tribunal. I am blaming it. Yes, my Lord.
First and first, we give you a few minutes, check your email as confirm if it is there.
As a
We give
publicist.
you a few minutes, check your email.
My Lord, might be guided by the date so that it will be easier for me to search.
25th March.
Thank you, my Lord.
March 2026.
Yeah, my Lord, I can confirm that there was a message like that. Can the tribunal hear me?
Yeah.
I've checked my mail. I can see that that means that I've been chatting with even Abuji Vincent sent me a message on that date, and then attaching a document. I can confirm that. However, we sincerely apologize for our inability to see the document on time and to react to it.
You say,
however, we sincerely apologize, my Lord, for our inability to see the document on time and react to it. My email address is clogged with so many messages. And my regular contact with the tribunal has been WhatsApp.
You also submitted your email address.
My Lord, I'm not disputing the submission. What is? Can I be heard? Sorry, I cannot hear. Can you hear me? Can I be heard? Please, I can't hear the tribunal.
One,
Yes, my lord.
there was a technical glitch.
Please. It's well, my lord.
This one does not affect the result. So, what do you
Okay,
say?
yes, I understand it now. It does not affect the result.
So, you have seen the motion. So, what's your reaction?
My lord, if I may be permitted, I will emphasize to the court that the motion is proposed to arrest the ruling of the court,
To the tribunal.
of the Honorable Tribunal, and the law is vehemently against such procedure.
But we have to take the application.
My lord, the law says, my lord, the tribunal should not take the application, but should strike it out. It's an abuse of court process, and I can cite authorities in support of that here and now.
Without hearing the application.
My lord, the procedure is that that application is unknown to law. It cannot be had.
Okay, well, let's take it down.
As the court pleases.
No, you are saying what?
My lord, we are saying that the application to amend the notice of appeal which has been challenged and argument issues were joined. And the preliminary objection was taken and reserved for ruling, was argued and reserved for ruling. Constitute an arrest, an attempt to arrest the ruling. And the law is that the Honorable Tribunal, before which such an application is brought, should refuse to take such an application for being unknown to law. And an affront on the powers of the tribunal to hear and determine applications brought before it. My lord, the reason for this is that where there is a challenge of jurisdiction in any proceedings.
One.
Yes, my lord.
Your argument is beginning to sound like you are responding to the application that has not been moved.
No, my lord, I'm mentioning the issue of okay. Let me stop at mentioning that it is arrest and then refer the court to the authorities. My lord, the authority for what I've said so far is Dr. Samuel Amade, and others. against Elder Iwezo. Iwezo is spelled I-W-E-Z-O-R.
Z?
I-W-E-Z-O-R, Iwezo.
Yeah.
Nweke Wolu. Nweke is N-W-E-K-E hyphen Wolu. W-O-R-L-U. Nweke Wolu. And others.
Citation.
2020.
Yeah.
LPELR.
Yeah.
51142.
Yeah.
It's a court of appeal decision, my lord.
Okay.
My lord,
Can you
another case of the Supreme Court.
Can you read it?
Okay, let me read it out, my lord. My lord, in Amechi, sorry, in Samuel Amechi, rather, not Amadi, rather. Sorry, my lord, it is Amechi and others against Nweke Wolu and others. Amechi and others against Nweke Wolu and others. LPLEA 51142CA. My lord, it is at page 49, paragraph A that I want to read now.
Wait. You gave LPELR.
51142. 51142.
Yes.
At page 49.
Yeah.
Paragraph A.
Okay.
It says, what the motion on notice was designed to do was to prevent the delivery of the ruling of the motion for interlocutory injunction by the learned trial judge. This is illegal and not supported by the rules of court. My lord, the Court of Appeal cited also the cases of Okachukwu against PDP, cited Newswatch Communication Limited.
Was to arrest the ruling on interlocutory injunction.
Injunction by the learned trial judge. This is illegal and unsupported by the rules of court. End of quote. Sorry, my lord, this is not the end of the quote. They said the court went on to say the learned trial judge was therefore right in so holding. What the court held there was that it cannot stop the ruling and that application cannot stop the ruling. And the appellant went on appeal, and the Court of Appeal said the trial court was right in refusing to take the motion after it has reserved an order for ruling.
Okay.
My lord, the Supreme Court also affirmed this principle in the case of Omar Ado against INEC.
Which case?
Omar Ado, Omar, U-M-A-R, Ado is A-R-D-O, against INEC and others.
Yeah, citation.
2017, 13 Nigerian Weekly Law Report.
Yeah.
part 1583.
1583,
my lord.
yeah, page what?
Page 450 at 483, paragraph F.
Page what? 48 what?
483, paragraph F, particularly the dictum of par argue JSC. My lord, the version.
Sorry. You said 48 something at 483.
483, paragraph F. 483, paragraph F.
Okay.
Particularly the dictum of par argue JSC, now retired.
Is it handy? Can you read it?
My lord, I can search for it now. Then the law pavilion version of it is 2017 LPELR 41919. 41919 SC. Page 47 to 48, paragraph E.
Okay.
Similar cases, my lord, are Newswatch Communication Limited. Newswatch Communications Limited against ATA. ATA is ATTA.
Yeah. So
2006. 13 Nigerian Weekly Law Report. Part 993. Part 993. Page 144 at 178 to 179.
yeah. So
My lord, the summary of the
you have
case
not
of my lord.
You have not finished?
Yes, my lord. I'm trying to summarize the case of Omar Ado and INEC so that my lord will get perspective of the point we are making.
Yeah.
My lord, all of us as lawyers know that the procedure for sealing and stamping of processes where not complied with is treated as an irregularity, provided that the party who is seeking to correct it or who made the error correct it within the right time. In Ado and INEC, it was contested that there was no sealing of the document. Parties joined issues on whether it is fatal or not. And the appellant counsel, whose notice of appeal was not sealed, maintained his position that he's on the strong footing. After the appeal was adopted and reserved for judgment, the Supreme Court gave a judgment that says that non-fixing of seal renders the document incompetent. And the counsel to the appellant now filed an application before the Court of Appeal after the matter has been reserved for judgment to now affix his seal. The Court of Appeal refused, and his appeal to Supreme Court was upheld. The Supreme Court disallowed the appeal, saying that it is not a denial of fair hearing. Timous action on issues of procedure were not taken can be fatal. How does it apply to this case? My lord, we argued the motion they brought for amendment earlier. This court tribunal struck out the application for being incompetent. Between the date of that ruling and the next date where the PO was heard, no step was taken. And the matter was heard and reserved for ruling. On the court list today, And on the virtual hearing that I got notice, the matter is slated for hearing, for ruling rather, and not for hearing of any motion. We urge the court, therefore, to uphold the position of the Supreme Court in ADO and INEC that it is not a denial of fair hearing. It is not a denial of fair hearing at all, especially in this case, where even after the delivery of the ruling, it took the tribunal to remind the appellant to get a copy of the ruling. Notwithstanding that the chairman drew the attention of counsel to the need to review their case after the ruling was delivered. So, having joined issues with us on the PO, and especially because there are other issues that the PO would decide other than the amendment, it will be overreaching to allow an amendment of part of the issues we have joined and reserved for judgment for ruling. The boss has left his station. And the next pertinent question to ask is that there are more fundamental issues of objection in the same PO that is reserved for ruling. Even if amendment to name is allowed now, will it cure all the irregularities? Some of them are so fundamental as being premature, the appeal being premature. Can that be cured by amendment?
Move on.
Yes, my lord.
The boss has left the station. But the passenger can join another one.
My lord, that will be in another station. You have to buy another ticket.
Then he can join another one.
Another one, yes, not this one.
Exactly.
Graciously, the court did not dismiss. I strike out. If they want to come back, they can come back.
Well,
but at this point,
let's say your letter colleague.
As a couple, please.
Yeah, I got your.
Yes, my lord, I think I'll be handling the matter because I'm a bit more abreast of the facts.
That's why.
No.
Go ahead. Go ahead.
Yes, my lord, we have a motion on notice, and counsel on the other end has been served. Our motion is ripe for hearing and subject to the competence of this honorable tribunal. My lord, we're ready to move same. My lord, it was filed on the 25th day of March 2026.
So you're ready to move the application?
Yes, my lord, for the avoidance of doubt, I want to draw the tribunal's attention to Order 11-1.
Are you moving the application?
Yes, I'm moving.
Are you moving it already?
No, not. I haven't gone to the application yet. For the I wanted to address some preliminary issues before I proceed to the application. Yes, Honorable Chairman, sir. If I may, with the kind permission of the tribunal, may I read the
Order what?
Order 11-1 of the Tax Appeal Tribunal Rules 2001. And it reads,
Rule what?
yes, my lord. Yes, and it reads, an application may be made at any stage of the proceedings.
You are moving the application. Yeah. I thought you were responding to him saying you are trying to arrest it.
My lord, the rules of this honorable tribunal.
One.
Yes, my lord.
Just let's reason together. Your APO, what is the anticipated result if he succeeds?
My lord, depending on the discussion of the tribunal.
I said if he succeeds,
Yes, my lord. I'm saying if he succeeds.
End result.
If he succeeds, what is the
that's the point I'm trying to make. There are two wings to it. Abuse of court empowers the court to dismiss. The presence of an abuse of court empowers the court to dismiss. However, the tribunal may decide to strike out. So it may be struck out, or it may be dismissed, depending on what the tribunal thinks meets the justice of the case. But the first point is that this matter was not brought to collect tax, but it was brought for self-aggrandizement. And that does not address the issue. This tax would have been paid long ago, if not for this action.
Those facts are not before us.
They are, my lord. We joined issues on it.
Okay.
We joined issues on it. So if this
there is for
self-aggrandizement.
There is for self-aggrandizement.
Yes, my lord, we argued it completely.
Can it be argued on affidavit or proof of or evidence?
It is supported by evidence, my lord.
That is for self-aggrandizement.
Yes.
Okay.
Because in our letter, we demanded to go to negotiation table.
Wait. Now you said the outcome could be if it's the abuse is successful, it's a dismissal. If it's not successful, it's a strikeout.
Yes, so, depending on what the tribunal decides to do.
Yes.
But
what happens if it's a strikeout?
My lord, they can come back. I've mentioned that before, and we are not worried about it. Let them bear the consequences of their inaction or actions.
Will you oppose it if they come back?
My lord, when they want to come, we'll talk about it. We are not at that bridge now. The point is to rule on the already taken PO. To do otherwise will be an abuse of court process.
Okay.
Yes, my lord.
We are disposed to hear their application. Can it be taken now?
If the court is disposed to hear the application, we will be asking for a date to enable us to put our response in writing.
Yes, we are disposed to hear them. So we can't just shut them out.
As the court pleases. But Lord, may we be given a date? May we be given a date to answer to why it should not be heard, so that it will be on
that. We have to rule on that application either way before we know whether it's an abuse or whether it is whether it succeed or fail.
At the court pleases. My lord, yes. May we humbly ask for a date to enable us answer to the motion. Haven't been drawn to our attention.
My lord,
just a minute.
Yes, Mr. Chairman, sir. We will be very opposed to the application for a date for the respondent counsel to respond to our application, which is right for hearing. Reason being that he has been served with this application long ago, and if he had any intentions to respond to it, he would have done that long ago. Any attempts to seek a date to respond to this will be viewed in our own opinion. Asala?
I got it.
Yes, my lord.
If we go on and on the next day he brings an application to respond to that your motion? Will it be shut out?
No.
So why should we proceed on the
Something that is
on
not
something that we know we
still in the range. It's not really yet.
so, you know, this kind of your opposition will not
My lord, in the circumstance, we'll leave it at the discretion of the
we'll
court.
give him time to respond. He said he wants to respond.
Yes, however, we be,
The application.
yes, that's what I'm going to. However, if subject to the comments of the court, we are ready to move the application.
I don't know what I said now.
You don't say most of that.
He said he wants to respond to it.
As,
And you say you are
as tribunal,
and you want to move the application.
as tribunal, please, we'll leave it at
We are giving you time
at the
to
discretion
respond.
of the. Yes.
Adams, what's the date? 20th, 21st,
That's right.
20th. One.
Yes, my lord, of this month,
Yes, May
No,
May,
May.
May,
20.
my lord, is it May?
20, yes.
May.
It's a Wednesday.
Okay, let me look at my diary, sorry.
20.
Is it
May.
good for them?
Yeah.
No,
They will hear
it's convenient for us. However, we have one very small application, innocuous one to make. That
My lord,
But let's hear.
moving forward.
Let's hear. Yeah, one.
my lord, the 20th is convenient. 20th of May is convenient.
Yes,
No closer.
yes, Mr. Chairman, sir, on the next adjourned date, we are opposed to this matter being held virtually.
Well,
Yes, my lord, yes, it's contained in the rules, and the rules also
I
state.
want to know why you want to.
No, my lord, you know, this back and forth, it's even in the best interest of the respondents' counsel. Because perhaps when he's in court, it will foster better understanding that.
Don't argue for me, argue for yourself, please. Don't represent me. You have no competence, you have no brief. Speak for yourself. Don't speak for me.
One.
Yes, my lord.
Yeah, before the tribunal.
Yes, my lord. I'm very sorry for addressing him directly, but my lord should take judicial notice. You should take judicial notice of this point. It is repeating and repeating again to show that this matter is not for justice.
My lawyer.
One, let's speak like
Counsel, so it's a lot, actually.
like
Professional.
Polish and French. Give them 20.
Maybe he wants to go physical in Benin when I come, since he's not having his way legally.
And you are scared of being physical.
My lord, he can't beat me, surely. In 21st, in this age and time, you are opposed to virtual hearing.
This case adjourned to the 20th May 2026 for a motion on notice to amend the notice of appeal.
As a copy. Sorry, my lord. Sorry, my lord. My lord, the ruling. Sorry, my lord. The Honorable Tribunal, please, I'm challenged. There's nothing said about the ruling that is reserved for today, which is the subject matter of today's proceedings.
The ruling cannot be taken. We hear that application.
Sorry, my lord, I didn't get it.
Let the application first.
Please.
For the next case.
Adam, my lord.
Huh?
Honorable plea, with this honorable tribunal, is the serious plea, my lord. I have 12 o'clock.
So I think that the ceremony was done to some.
I wanted to please, I have the 12 o'clock hearing at the High Court, so I thought by now I would have.
Which one was adjourned?
Mine is seafood, man.
Say which one was adjourned? You got a date here, then you went and said that it's Thursday.
My Lord, at the time I
What is this for?
at the time I got it was for
So if you have a job of office, look at the time.
yes, my Lord, I'm already, I thought by now, the
what do you
ruling
want?
was really.
What do you want to do now? You want to go on with the hearing or you want to take a date?
No, Lord, if we can even have a challenge. The document that my Lord requested for, we have them, but one of them, I've not been able to print it out with the way it was set on it.
So what do you
So if I can be obliged with a date, a short date, my Lord, I will appreciate it. Thank you, my Lord.
Number 4.
Number 4, on the course we have seen number 86, ISS, I don't want to submit 25. Let's see what the internal revenue of 6 votes will raise any station.
Would have said that sense, so would have allowed you to go to your.
As a company, I didn't want to disrupt the proceedings of the court. I'm most grateful.
The next time, don't adjourn another case.
I appreciate my Lord. Just as at the time I came for the dates, the date has already been fixed. So we have to.
You were enjoying the proceedings. You were enjoying the.
No, because of the holiday, the public holiday, that the last adjourned date fell on the public holiday. Yes, ma'am.
Appearances.
The Honorable Tribunal. I am the Kokoja. Appearing me is PP Agari. We humbly appear for the appellant.
Yeah.
Thank you, madam. Provide ability to this honorable tribunal. I am UF Amadasu. I love my number representation is for the respondent.
Say consider.
No, my lord.
Yeah.
My lord, ordinarily it was for tendering of document and requested by the tribunal for us to present certain documents that were listed for us. Certain documents, my lord, that were listed for us, which was the approval for 2019 to 2021, timesheet invoices, and employee names, address.
Produce some documents.
Yes, madam.
Yeah, so.
Although some of the documents are ready, but some are not available, madam. So in the circumstance, we are pleading with this honorable tribunal to avail us a short
We are taking you, we are recording you.
Okay, so madam. Asking for a short date, ma'am. Available to the tribunal.
Yeah, okay. I mean, what do you?
Mr. Chairman, we are not opposed to the respondent's application for a date.
What is?
Yes, my lord.
You see, if it's you, you will object.
Sir?
If it's you now, you would have objected.
No, my lord has since pegged me to the wall. And this is
My lord, in the
this is
hands of God.
Tribunal. This is Tribunal. So
You would have objected and asked for God.
no, but we have never asked for cost. So my lord has made me to understand that this is not our regular court. So it is a Tribunal. So
Because we always follow the bank.
so since that time, my lord, I've learned how to yes, my lord. My lord will observe that we no longer object.
If you were deserving of the cost, why not?
Thank you, my lord.
Right, yes.
If you can see the thing.
21st?
Yes, 21st is clear for me, my lord. Wait.
21st?
Yes, my lord. Very clear, my lord.
Is it convenient for?
Yeah.
My lord, we would have prepared the 20th, just that it's not convenient for him. Or
Yes, I have
You
to.
don't need to take a data, it's not confident, I will come here, what happened?
Maybe an earlier date, maybe more.
No. If necessary to.
My lord,
Yeah,
your 21 is very clear.
I will drive now, please.
But most people.
Google here is in Benin.
Thank you.
You say Benin.
My lord, people there might not even be in the country.
21st?
Yes, my lord. 21st day is a Thursday, my lord, of May 2026. Yes, my lord.
The consent of both parties, this case is further adjourned, the 21st of May, for hearing.
Someone group my lord.
He doesn't always go until that. Adams. What was this in here? This was for 20th of February. What about it? Doesn't close.
Number 3 on the course of opinion number T8 is that every I don't think it's by 25. I have people of internal arrangement of work with you. First week and
Seek the permission to.
We can't hear anything from here.
Who is talking?
I think it's just to.
Is this Bishop?
yes, sir.
Okay. Appearances?
May please the Honorable Tribunal. I am V.E. Procodia. Appearing with me is P.P. Ajari. We humbly appear for the appellant.
No representatives. No party representative.
No, it's not party representative.
Yeah. Respondents? Westfield. At the last, okay, Anastasia, wait. You know the lady that came from Lagos?
Yes, sir.
That respondent was represented, party represented by Ms. Bola Sadi, Naral Council. company secretary with Tina Sherry, chief financial officer, and Omod, Franklin. Where are they? Are they there? Respondents?
I'm for respondents, sir. My name is Sylvester Innocence.
Sylvester Innocent.
Yes, sir. I'm appearing with Anastasia Moye, but she just left the room a few minutes ago. So just in case she comes, right?
She's not appearing. You're not appearing with anybody there. Just with myself.
Okay, sir. Okay, she's here, sir.
Anastasia?
Biggest honorable tribunal, please. Anastasia Way.
Somebody had somebody announced appearance as appearing.
They appear, it just appear.
Who is leading?
Yes, again. Sorry, sir.
Who is leading?
Okay, I'm reading the matter.
Who is appearing now?
It's Anastasia that's leading.
Anastasia Way.
You are leading Sylvester Innocent.
Yes, Mr. Chairman.
Yeah?
Where are your party?
Any party rep?
You don't have your party.
No, parties are not present.
Yeah? What are we doing today?
Honorable members of the tribunal, as at the last adjourned date, tribunal members adjourned for hearing of the motion to amend. We filed a response to that motion, and we have a pending motion to regularize our contact with that and written address. I would like to proceed with that.
Are we, what are we supposed to do today? What was adjourned?
At the discretion of the tribunal, yes, it was adjourned for hearing of the applicant/applicant's motion to amend the notice of appeal, which we were served with on the last adjourned date. So we had sought another date to afford us opportunity to respond to the motion to amend, which we were served with at the tribunal as at February. So we've now responded to that motion to amend. Have found our counter affidavit and written address. We also have a motion to regularize since in the absence of.
Are you opposing the application to amend?
Yes, we are vehemently opposing it.
Huh?
Yes, Mr. Chairman, we are opposing the application to amend.
Oh dear.
Mr. Chairman, just need to confirm with everyone that Gary will be handling the season address. In that sort of case.
The motion of amendment.
Is there a motion?
To the one for 22nd January.
Yes, Mr. Chairman. Yeah, the one for 22nd January 2026 is
Then I'm ready to, Where's the response?
Yeah, right.
The apparently they are filed. They are putting this motion. Okay. Yeah. And wait,
Yes, Mr. Chairman.
we see that you filed a motion.
Yes,
A
we
motion.
filed a motion to, yes, to regularize,
Filed a motion for
On-
extension.
yes,
File your counter affidavit.
and written address. Yes, Mr. Chairman.
Was that what necessary?
We noted that the rules of this tribunal had no timeline as to when to respond to a pending motion.
It's a counter affidavit, so maybe what
Yes,
we'll
so,
do, we'll make things
yes.
easier. You can apply to withdraw that petition.
Sorry, sir.
You have already filed your counter affidavit. Have you not?
Yes, we have. Yes, we have.
I'm saying the motion to for sake of time to file your counter, you can apply to withdraw it. So that we'll go on with the motion.
As the tribunal please.
You understand what
We move. Yes, Mr. Chairman.
you can apply to withdraw the motion for extension of time. Or you have already filed a counter affidavit there, the motion for amendment.
Yes, Mr. Chairman, it was just to regularize the process before the tribunal members.
We understand you, that's what I'm saying, it was unnecessary.
Okay, oh, thank you, Mr. Chairman. We withdraw the application.
That's why I'm saying to apply to withdraw the motion for extension of time to file a counter affidavit. We should try the next.
Thank you, Mr. Chairman. We withdraw the application. We can proceed to hearing of the motion to amend.
You finally reply, other than.
No, there's no reply, we need file.
Yeah, great. Yes, I'd like to withdraw the motion. For the person of time to file an affidavit.
We're not opposed to the said application. So,
The motion on notice filed on the 24th of March 2026 was stated of time to file a counter affidavit by the respondent having been withdrawn is hereby struck.
As general business.
Now we have a motion on notice for amendments. Well, are you ready for the take that?
Yes, Mr. Chairman.
Okay. Okay. We got the counter affidavit.
Yes, we did.
Okay. You can move the application. For amendment.
Oh. Okay, yes, before the Honorable Tribunal is a motion dated and filed on the 22nd of January 2026.
Make sure your letter friend is sharing it.
They should speak. Yes, Mr. Chairman, the motion is brought pursuant to dated and filed on 22nd day of January 2026.
Yeah.
Mr. Chairman, the motion is brought pursuant to Order 11 Rule 1. And under the earlier jurisdiction of this Honorable Tribunal. Mr. Chairman, our motion
The level rule.
Rule 1. Order 12.
Yeah.
Yes. Order 12 and Order 25, Rule 3 of the Tax Appeal Tribunal Procedure Rules 2021, and under the inherent jurisdiction of this Honorable Tribunal. Mr. Chairman, our motion is pray for an order of this Honorable Tribunal granting leave of the appellant, respondent, to amend the notice of appeal and all other accompanying processes by correcting the name of the respondent from Westfield Energy to Westfield Energy Resources Limited. We're also praying that this Honorable Tribunal deem the proposed amended notice of appeal and accompanying process is already filed and served. Also for an order dismissing the respondent's applicant's notice of preliminary objection dated 18th day of December 2025 for lacking.
Are you moving it together? They filed a notice of preliminary objection. When was it filed?
It was filed on the 18th day of
December.
Yes.
So you now, instead of reacting to it, you are now bringing a motion asking us to dismiss that application.
It's just part of our prayers on
Asking. Is it tidy? They filed a motion, and you didn't respond. You didn't respond to it. You are now bringing another application asking us to dismiss an application that was not there.
I think it's just taking it on. It's not time yet.
Mr. Chairman, we just.
Ordinarily, we are supposed to take their own application first.
Yes.
So assuming we took the application first, it means you didn't respond to it.
We just lumped up the
You are taking it because this one for amendment seems to is to preserve.
Yes.
So if you are not bringing the other application inside it, you have not responded to it. So you want us to now rule on that application that we have not taken.
Mr. Chairman, will take the hint of the tribunal. Mr. Chairman, our motion is supported by an affidavit opposed to by.
Just a minute. Yep, you tell what.
Yes, Mr. Chairman, our motion is supported by an EP paragraph affidavit opposed to by Sheila Kelly Norma Ugweke. And
Supported by what?
an 18 paragraph affidavit. By Shelley Norma Ugweke.
You don't get the name of your deponent. We are finding it difficult to pronounce it. See yourself.
Yes, she's a core member serving with the legal unit.
And she is best with the facts.
Yes.
Yeah.
Yes, Mr. Chairman, we've also attached the recent address and 3 exhibits.
Yeah.
Yes, Mr. Chairman, will be ordering this honorable tribunal to grant our application for amendments in the interest of justice. We're most grateful.
I see that you don't know how to optimize your prayers. For ease of reference.
Yeah, I think it will.
No, that's what I wanted to ask you. What is the prayer? What? How do you refer it?
I just come from
Yeah? I think you should withdraw the other prayer. The one that is
yes.
other dismissing.
Yes, Mr. Thomas, I haven't taken the hit of the court trial.
Don't take a hint. Make your submission.
Mr. Chairman, we humbly submit that the prayer 3 on the face of our motion, we seek to withdraw it. We're most grateful.
This is.
Yes. So,
Oh, yeah.
Yes, Mr. Chairman.
Your elected colleague, he said he has applied to withdraw. You know, there are 3 prayers on his motion. He's applying to withdraw the 3rd one.
Yes, Mr. Chairman, we already argued in our counter affidavit and written address that the appellant applicants cannot, by virtue of their motion to amend, purport to seek a relief that warrants the honorable tribunal to dismiss a plenary objection, which is yet to be heard, and which should have been heard first. But in the interest of justice and considering the nature of the application before this tribunal, is now being heard first. So it amounts to abusing the offer of first rights or priority afforded to the appellant applicants to proceed with their motion on notice to amend. So we've also argued that in a written address in response to the application. And we are not opposed to the tribunal striking out the particular relief which seeks to dismiss a notice of plenary objection. We can proceed on the basis of other prayers before the tribunal.
The 3rd prayer on the appellant's motion on notice to amend the notice of appeal for dismissal of the respondent's relief objection. That will be withdrawn, struck out. Sir, your
Yes, Mr.
response,
Chairman.
you heard your colleague, he has moved his objection.
Yes, Mr. Chairman, we oppose the appellant applicant's motion on notice to amend on the basis that what has been sought to be done is not a correction of the process that can be amended. So the notice of appeal that we have before the Honorable Tribunal is a defective one and incurable, so that an amendment to rectify the defective notice of appeal is not something that can be done in law. We've made very elaborate arguments in a written address, and you can elaborate further if the tribunal pleases. We filed it. Sorry?
Just a minute.
Okay. Yes, sir.
That you said you are posing
The application,
I mean, it's just about years. So, and you said you are filed what?
we filed a counter affidavit, a 9-paragraph counter affidavit in opposition to the applicant's motion and notice.
Paragraph, but it's normal. You can pass for over 30 paragraphs. Okay. But,
Yes, a 9-paragraph, yes, a 9-paragraph counter affidavit.
9 paragraph. Yeah.
Posted by one Mr. Omotola Oni. Oni.
Yeah.
Yes. On the 18th day of March 2026.
Then there is also the original address.
Yes, attached to the counter affidavit is the written address. Also dated and filed on the 18th day of March 2026.
This file is separate. Okay, okay, I've seen it. Yeah.
Proceeding to rely on a counter affidavit and motion and written address rather, and adopting as an argument in this matter.
Yeah.
Mr. Chairman, if the tribunal pleases, we wish to elaborate on content of our written address for as few as 2 minutes.
There is no need. You have adopted it.
Okay, Mr. Chairman. We just also wanted
You
to
have
highlight
adopted it.
that.
You have adopted it, so we'll look at it.
Yes, thank you, Mr. Chairman. We only just thought to mention that the applicant had failed to file a further affidavit or reply in response to our counter affidavits, and it may be deemed acceptance of the position canvassed in our counter affidavit and written address.
You didn't know address that in your address. You don't put that in your address. Where is it?
Sorry, Mr. Chairman, we've not been served with any, so we assume they have no intentions of filing it.
What I'm saying is, you didn't make that point in your address, your address.
Mr. Chairman, we had to file a counter affidavit first, be sure they received it, and then wait some days to receive their counter affidavit because we've not received any until today. And it's been almost a month since the service of our process.
Counter affidavit to which one?
To their motion to amend,
Yes.
the notice of appeal. We filed the counter affidavit and written address, and they've not found a reply.
So that lacuna is deemed not to have. She said that since there was no reply, so she's assuming now that they have accepted the value. That is what she is saying. Why did you fight? What was the fighting for that?
It was until yesterday that was even brought to my attention by them. This until yesterday, and he knew my state as at yesterday. They wouldn't have.
Remember, I asked you.
Yes, you did.
That's a police case. It's important. It's not in all cases.
Yes, Mr. Chairman, we understand the position of the applicants, but if truly this matter was brought to his attention only yesterday, I think it would have been prudent for him to have mentioned that the applicant still intends to file a further affidavit or a reply in response to our counter affidavit. Granted that it's not within our place to bring the matter to his attention, considering that it's the ones that brought us to court. I don't think that the position that sorry, Mr. Chairman.
I said nobody has faulted you for not bringing it to his attention.
Exactly, Mr. Chairman. We don't know how it works in his office, but we've been brought to court, and we note that due diligence should be equally applied by the party who has sued us on their end to ensure that all processes are properly before the tribunal, before the due date of the hearing. So if that was their intention, that should have been mentioned from the onset.
What's happening? We can't see you clearly.
She's the second, is sitting there in the middle.
Where?
Mr. Chairman,
The second after the house is number 2. She's the second.
Okay. Who was still there?
yes,
my
Mr.
lord.
Chairman.
Yes, Mr. Chairman. Yes, Mr. Chairman.
What are you doing here? You are here dropping.
I am the tribunal. The tribunal should try matters in public. I am the public here.
Okay, who are you?
Yes, Mr.
Is that
Chairman.
all? Is that all?
Yes, Mr. Chairman, our position on further affidavit and reply is premised on the Supreme Court case, 2025 Supreme Court case, Ola Kehinde.
Ola what?
Ola Kehinde.
Kehinde is what?
It is Kehi.
Ola Kehinde.
Yes, Kehinde. Kehinde.
Kende. Yeah?
Kehi.
Kehinde.
Yes. Ola Kehinde against EFCC.
Ola Kehinde. Ola in the West Village. Like who?
Against EFCC.
Against?
EFCC.
Okay,
2025.
yeah,
17 Nigeria Weekly Law Reports.
yeah,
That's 2014.
yeah,
At page 241, particularly at page 282.
yeah. Paragraph what?
Paragraph C to F.
Paragraph,
C to F.
okay. Court of Appeal or Supreme Court?
Supreme Court.
All right. Yeah. any
Also,
further?
yes, the case of Sanya Olu.
Case of, are this not in your written address?
Written address.
They are in support of this.
They are not in your written address.
Sorry, Mr. Chairman. Yes, I can hear you, but I did not get the question.
I said these cases are not in your written address.
No, sir. So the cases are on the fact that
Okay, let's
the
hear it. Let's get
applicants ought to have filed further applications on level.
the second case.
The second case, Sanya Olu.
Huh?
Sanya Olu is spelled SAN.
Yeah.
IAOLU.
IAO.
LU.
L what?
Against Adekunle.
Against
Kunle. Adekunle is spelled ADE.
I know I didn't.
KULLE.
Yeah.
Citation is 2006.
Yes.
7 NWLR.
Yeah.
But 980.
9.
980. 980.
80. Okay. Page.
Page 551, particularly at pages 561. 551. 551.
No,
551
At 561, paragraphs D to E.
Yeah.
Yes. So, Mr. Chairman, those cases buttress that in the absence of the further affidavit or reply, counter affidavit and written address will be deemed considered by the applicant, and we assert the same position.
It's okay. That's all. Thank you.
Yes. Thank you, Mr.
That's-
Chairman.
Okay. I got it.
Yes,
You got it.
yes.
Taxing authorities that I did.
Yes, Mr. Chairman,
Look at them.
Mr. Chairman, notwithstanding the beautiful submission of my learned friend on the other end, we repose confidence in this honorable tribunal to do substantive justice. Looking at all the processes that we've already filed,
Very good. question, Justice.
Yes.
And you said you have what?
Subject to all processes already filed.
Yeah.
And Mr. Chairman, notwithstanding how beautiful submissions of councils are, they don't take the place of evidence. Everything that ought to have in place the cart before the horse, and they are all before the tribunal. So we'll leave it at that.
They don't take the place of evidence.
Yes, no matter how beautiful they are,
Yeah.
they don't take the place of evidence.
Yeah.
And we've presented certain evidences before this one of the tribunal, and we'll leave it at that.
Yeah. Let's give the date for it. Sorry. It's a tribunal need to be here.
Come back and forth.
Okay, okay.
Or we can done virtually.
Come back to.
No, but the day Thursday, perhaps.
Thursday. Thursday is what days? Six. Don't judge me where. Judge me. Don't know about it. Okay. Warrior. You said 28. So what days?
On Thursday.
What days? Which Thursday?
Thursday 21st, we still closed.
That's me.
Yes.
Warrior. Warrior, are you there?
Mr. Chairman, yes, I can hear you.
21st May
28? No, it's not convenient, Mr. Chairman.
is for ruling.
It's not convenient.
For ruling. You are appearing with two other people there.
Mr. Chairman, we'll both be another courts on that day.
All of you.
So we work on separate matters. So you'll be in a different court and I'll be in a different court. But 22nd is fine.
Okay. Case is adjourned to the 22nd of May 2026 for ruling on a motion on notice by the applicants to amend the notice to appeal.
As a tribunal, please. As a tribunal.
What break today?
I thought this one would be. It's like this. Yeah, but you don't want to talk.